The unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis is going completely over the edge. El Salvador is a sovereign nation. We don't have authority over it or its citizens. What are we, colonizers? Judge Xinis? This is privileged information to which the judge is not entitled. As a matter of constitutional law, she does not, in fact, have infinite authority over all the things. She's not actually a queen. I want better answers. I want answers that make me happy. I want Abrego Garcia back in the United States and Maryland man. He's just a Maryland man. Utter madness. Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified. And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive, adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding, gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you. So it looks like another judge has been just driven crazy by Trump. And this has been going on for a while. I'm talking about Judge Paula Xinis overseeing the case of Maryland man, our good friend, Kilmar Armando Abrego Garcia, currently residing, I believe he's residing, in the tropical El Salvadoran prison resort of Sicat, down in El Salvador, his nation of citizenship. The unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis is going completely over the edge. At this point, I have to believe it's just provocation by President Trump and his administration into the greatest degree of insane and petulant overreaching I think we've yet seen in all the lawfare being waged against our elected Article 2 executive branch president by these TDS-afflicted, inferior Article 2 judges who mistakenly believe they possess unlimited and infinite authority. So yesterday, Judge Xinis released yet another one of her discovery orders. She's not happy with the White House and the manner in which it's failing to bend the knee to Queen Xinis to the degree she would like. She's ordered them by 5 p.m. every day, White House. You will submit to me a status report. Well, they've been doing that every day. And one they submitted yesterday, she's ordered a bunch of discovery. You will answer these questions in my court every single day. And the White House objects to this. They submit the status reports. They decline to fully answer her questions because of a whole variety of reasons. I'm not going to read their whole filing here, but because mostly it's repetitive. So they submitted their update yesterday as ordered by Queen Xinis, and they added an appendix. The appendix is just kind of a sworn affidavit by one of the people involved, and they list their objections. The White House objects to having to answer all these questions, and in fact doesn't fully answer all the questions. A lot of them, reasons they don't answer is because calling for information that is, we object because the court is calling for information that is protected by the attorney-client privilege the deliberative process privilege, the state secrets privilege, and the governmental privilege. This is privileged information to which the judge is not entitled as a matter of constitutional law. She does not, in fact, have infinite authority over all the things. She's not actually a queen. The Article 2 executive branch is not inferior to the Article 3 judicial branch. So they list all these objections repeatedly to each of the areas of questions that Paul Xinis demands answered. But there's one point I want to get to right in particular. Here's one. Defendants object to this particular question because it's based on the premise that the United States may exercise authority over Salvadoran citizens detained by El Salvador within the sovereign territory and pursuant to the domestic law of El Salvador. El Salvador is a sovereign nation. We don't have authority over it or its citizens. What are we, colonizers? Judge Xinis? And then they go on to make clear. One of the questions is from Queen Xinis, list each payment that has been or will be made or withheld in connection with the detention at CCOT of Abrego Garcia. How much are you paying El Salvador to imprison Abrego Garcia in CCOT? This is the tangential authority grasp that this judge mistakenly believes the U.S. still has over Abrego Garcia, that we're paying for him to be detained in CCOT. Here's the answer. Defendants respond as follows. The United States, through the White House spokesperson, has publicly stated that approximately $6 million has been made available to the government of El Salvador for its law enforcement needs, including for the detention of these Venezuelan foreign terrorists, TDA. Is Abrego Garcia a member of TDA? No, he's a member of MS-13. The United States has not provided any specific assistance with respect to the detention of Abrego Garcia or any other Salvadoran national. We're not paying El Salvador to detain Abrego Garcia. If he's being detained, his own government is doing that. And guess what? They're allowed to do that. He's their citizen. You nut job, Queen Xinis. So she doesn't like all this boilerplate she's been getting from the White House. So yesterday she issues perhaps the most petulant order we've seen yet. This is the one that's 8 pages. We'll go through it pretty quick. I haven't read it closely myself, so we'll be all seeing it for the first time. She's very upset with the White House because they're not answering her questions to her satisfaction. So, pursuant to this court's letter order regarding the filing of discovery motions, she wants like senior members of the White House administration to appear in her court and testify under oath about all this in a case where she has no genuine jurisdiction. Remember, Abrego Garcia was returned to El Salvador on March 15th. It wasn't until 9 days later that a complaint about Abrego Garcia was filed in her court. He'd been in El Salvador, in El Salvadoran prison, an El Salvadoran citizen in El Salvador, subject to the sovereign will of El Salvador, with no further connection to the U.S. She has no jurisdiction over him at all, but she can't let it go. So she has complaints. Defendants object to certain discovery because the requests are based on the false premise that the U.S. can or has been ordered to facilitate Abrego Garcia's release from custody. Defendants and their counsel well know that the falsehood lies not in any supposed premise, but in their continued mischaracterization of the Supreme Court's order. The Supreme Court was also under the mistaken belief that the U.S. was paying for Abrego Garcia to be in CCOT. That is not true. We know it's not true. So that order from the court, at most, by the way, required facilitating the release of Abrego Garcia. To facilitate the release from custody. We have no authority over his custody. We're not paying for him to be held in custody. We didn't make that decision. If he's in custody, if Abrego Garcia is in custody in El Salvador, it's because El Salvador chose to put him in custody for their own reasons. The Queen. Defendant's objection reflects a willful and bad faith refusal to comply with discovery obligations. The objection is overruled. Defendants, the White House, the Article 2 executive branch of government, elected by the whole of the American people to exercise their political will, in particular in the subject of deporting the 100 million illegal criminal migrants we have in our nation. This Article 3 unelected, black-robed, tyrannical, inferior district trial court judge waves her scepter and orders that Article 2 executive branch is ordered to supplement their answers in full compliance with the federal rules of civil procedure. The answers must include facts responsive to requests, not oblique and incomplete, non-specific characterizations. Do it the way I want you to do it, President Trump. She says, equally specious, defendants' objections on the grounds of privilege are rejected. Defendants invoke in name only a range of protections: attorney-client privilege, the work product doctrine, the deliberate process privilege, the state secret privilege, and an undefined governmental privilege, without providing any supporting information or analysis. Now, if she were talking to a normal plaintiff, she'd have a legitimate complaint here. You can't just say, I'm not going to answer attorney-client privilege. You have to be able to demonstrate why it qualifies as attorney-client privilege. But she's not speaking to a normal plaintiff. She's speaking to a co-equal, arguably superior branch of the federal government. They're not a normal plaintiff. They have core and plenary powers under the U.S. Constitution that are beyond the reach of this unelected black-robed tyrannical inferior district trial court judge. This is utter arrogance on the part of this judge. The executive branch objects to any discovery request concerning events prior to the court's April 4th order for discovery. Defendants' arbitrarily cramped reading of the court's order is rejected because this queen demands to know all the things. At a minimum, the discovery period contemplates the time immediately preceding Abrego Garcia's lawless seizure on March 12th. He was not seized lawlessly. This is a lie. He had a final order of deportation since 2019, 6 years ago. In February, MS-13 was designated a foreign terrorist organization. Abrego Garcia had been adjudicated with all due process, represented by counsel, in immigration court and on appeal as a member of MS-13. As a foreign terrorist organization member, he's subject to summary deportation independent of his already existing final order of deportation, and he's no longer eligible for withholding. So his withholding order from El Salvador is null and void. He was not lawlessly seized, and he was not transported and confined to CCOT by the U.S. government. He was transported to El Salvador. El Salvador then decides what to do with him. They don't put every of their citizens deported from the U.S. to El Salvador into CCOT. They make their own call. That's got nothing to do with the U.S. Let's see, what else here? Defendants further object to discovery that is supposedly outside the scope authorized under that April 4th order, seeks information about his removal to El Salvador, his initial placement in CCOT, or his continued confinement in CCOT. Well, America has nothing to do with that. Yes, we removed him to El Salvador under a final order of deportation and the designation as a terrorist. His placement in CCOT was by El Salvador, and his continued confinement in CCOT, if that's what's happening, I don't know, but that's the call of the sovereign nation of El Salvador. She wants to know what steps the United States will take to facilitate his release from custody. We have no authority over that, and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. By the way, the U.S. answered that in the appendix. I forgot to touch upon that a moment ago. If we have time, I'll go back. But what the U.S. said in its filing, to which this is a response, is that, listen, if he came back, we will facilitate his reentry into the U.S. If he shows up at a port of entry somehow, we'll let him in, and then we'll detain him. We'll put him in a detention center, and we'll deport him to some other country in the world, or we'll invalidate his withholding order and send him right back to El Salvador. That's how it would be handled had he not been, quote unquote, improperly sent to El Salvador in the first place. He was not improperly sent. It's all madness. Madness. Let's see. Then she doesn't like who's been named as involved in this decision-making, who's been giving her the status updates. She wants more senior people to do that. Maybe President Trump himself has to appear in her court to her satisfaction. What about seeking the complete factual basis for defendant's assertion that Abrego Garcia is a member of MS-13? This has already been adjudicated by the appropriate court with all due process while Abrego Garcia was represented by counsel. This question has been answered. It was answered 6 years ago. Due process isn't just what the person gets to claim. Due process gives benefits to the government too. And one of those benefits the government gets is finality. Due process does not mean you get to litigate an issue relentlessly, infinitely, until you get the answer you want. At some point, the question has been answered. Here, membership in MS-13 was answered in immigration court where it belongs. This is not within the jurisdiction of a federal district trial court judge. They don't have jurisdiction over these immigration matters. Congress took immigration jurisdiction away from the federal district trial courts and gave it to the specialty courts created by Congress for immigration purposes, our immigration courts. The White House has previously articulated in their daily updates as to Abrego Garcia's custodial status and his potential return that DHS, if he came back, would take him into custody, remove him to another country, or terminate withholding because of his purported membership in MS-13. Yes, exactly right. The question has already been answered. Based on the foregoing, the White House objections are largely overruled. She doesn't like them. I want better answers. I want answers that make me happy. I want Abrego Garcia back in the United States and Maryland man. He's just a Maryland man. Utter madness. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.